And I guess we can start. Thank you all for joining us today at the IP rights webinar within the series of UK-Russia legal discussions arranged by DIT Russia together with RPCC. This is our second webinar in the series, and it's great to see you all here. And before I give the floor to Alf Torrens, Executive Director of RBCC, I would like to say a couple of words in the Russian language, instructions for those who would like to listen to the webinar in the Russian language. Дорогие зрители, слушатели, весь вебинар будет проходить на английском языке. Тем не менее, если вам необходимо слушать вебинар на русском языке, такая возможность есть. Необходимо скачать приложение Speakers и ввести код 440354. Инструкцию на русском языке я также добавлю в чат. Okay, thank you all. My technical instruction is over. I'm very glad to see all our speakers today. These are Julia Gurieva, Katerina Polikova, and Grigory Moskalyov. And Alf, please, the floor is yours for the welcome speech to open our session.
Anna, thank you very much, and it gives me great pleasure to welcome everyone to today's webinar, during which our expert panelists will consider various aspects of intellectual property. Once and again, I'm delighted to have been invited to make some opening remarks for the latest in this series of DIT-organised legal webinars. As Anna mentioned, my name's Alf Torrens, and I'm the Executive Director of the Russo-British Chamber of Commerce, and we've partnered DIT for this excellent series of legal discussions, which aims to explore some of the complexities of the legal landscape as it pertains to Russian and UK business matters. As always, a big shout out to Trevor Lewis, Director of DIT Russia, Ludmila Stepanova, Team Leader, and of course, Anna Rozanova, Senior Trade Advisor at DIT, for organizing these events, which I know are extremely well received, and I've had lots and lots of very positive feedback. So a big thank you to all of you. As I've said on more than one occasion, as a business chamber, we recognize that a strong legal system underpins good business practice. In a challenging political relationship, legal services is an area where more can be done between the two countries, and this, of course, we support wholeheartedly. IP is both an extremely important and I personally find fascinating area. And telling a war story or two, I remember back in the day when I lived here in Moscow many years ago, I remember vividly that the US ambassador and several other ambassadors from Western countries used to regularly complain and physically go up to Izmailova market to complain about pirated DVDs and CDs. Now, I know this dates me a little bit, but I also think you'll agree it's become an increasingly difficult area as ideas and knowledge become more and more important part of trade. And many products that used to be traded as low technology goods or commodities now contain a higher proportion of invention and design in their value. And of course, maximizing the value and impact and protecting these intangible assets is central to more and more companies, and of course, not only in the tech sector. I'm not a lawyer, I'm no expert, but from what I've read, intellectual property protection in the modern sense is still considered quite a young sport in Russia and continues to evolve rapidly, making these discussions all the more important and all the more timely. And as Anna's already introduced, we have a great panel of experts to do exactly that. So with no more ado, I'll hand back to Anna so she can cue the first speaker. Again, very warm welcome, and I hope you enjoy today's event.
Alf, thank you very much for the kind words and for this great welcome speech. You opened our session, and our today's first speaker is the expert from KPMG, CIS Russia, that is Grigory Moskalyov. Grigory, you are welcome to start.
Thank you, Anna. Okay. My name is Grigory Moskalev. I'm a manager of IP practice in KPMG Law, and I'm a trademark attorney, Russian trademark attorney. Today, we want to have a discussion on the most significant violations of IT companies when they work with IP. Over the past few years, we have conducted numerous of legal due diligence of IT companies and have identified interesting and significant violations that can lead to adverse consequences for companies. Given that IP is most often considered as a main asset of IT companies, violations related to IP rights allows the buyer or investor to lower the valuation of the company in negotiations about buying or investing in a company. In this regard, we recommend to be very careful with IP rights formalization, and we hope that our short presentation will highlight some aspects for your future business activities. As we saw, as we analyzed, a lot of IT companies, a lot of startups we analyzed, they paid a lot of attention to the product itself from a business point of view, but not about its legal framework. On this slide, you can see the main problems identified in our legal due diligence procedures, such as that the company has had no internal policies or procedures to govern the creation of IP, that they had no record keeping of intellectual property, no job assignments had been formally issued, no procedure for acceptance of completed job assignments had been provided, and so on and so on and so on. So basically, a lot of startups, a lot of IT companies, they have a few formal procedures for formalizing IP rights objects. Further, I will tell you specifically about the violation we have noted as frequent or interesting from the point of view of intellectual property rights protection. First one. We have seen several times the situation where one software product is developed by several employees from several companies in a group, and sometimes even cross-border. At the same time, there were no documents formalizing such development between the companies. In fact, most often the beneficial owners of the group or top managers of the group believed that if it is a one group of companies, that there is no necessary to formalize anything. It's not necessary to draft any agreements between this group of companies. At the same time, it sometimes happens that a group of companies want to sell either the asset, the software itself, or one of the company of the group. And then when we start our legal due diligence analysis, we see that the development was carried out jointly by the group of companies and the employees from the several groups. So the IP rights belong to several companies of the group respectively. Therefore, there is a high risk of loss of exclusive rights of the intellectual property when the buyer or the investor will buy this software or will buy this company, which will be the joint owner of a software of an IP right object. Second violation. The next violation is that the company doesn't know who developed or invented an exact intellectual property object. In particular, it's a very common situation with images that were later registered as trademarks. Image trademarks are objects of copyright and that they have its own author. Accordingly, such an author must transfer the rights to a company that will subsequently be registered as an image as a trademark. Otherwise, the company might lose trademark rights. And in addition, the company may incur some financial losses due to the author's claim. That is why the company must actually identify the IP object was created in the company, and the company must have an agreement with such person, with such employee, so all the exclusive rights to be transferred to the company. The third violation. This violation we identify in almost 90% of our legal due diligence analysis. We analyze employees' agreements and see the following provision. The employee's salary includes remuneration to the author for all work created. So it's really almost 90% of our analysis. This position that the remuneration includes in the employee's salary is fundamentally wrong. The author remuneration is paid to the author not for the very fact of creation of the IP object, but when the employer begins to use the IP object or transfer it to another person. Moreover, such remuneration is of civil law nature and cannot be included in the salary by default. At the same time, the law does not define what should be the amount of such remuneration for copyright objects. Accordingly, it's better to agree in advance with the author on this amount than to pay later on a court decision, probably a much higher remuneration. Therefore, please make agreements with authors of intellectual property to provide for authors' remuneration and pay remuneration to authors for the intellectual property objects. It's very important. It's a really common risk we identify throughout legal due diligence procedures. The next violation I would like to talk about is a typical situation when the companies does not formalize any documents on the website development. So it's typically the company orders a development of a website from a third party, or some employees develop this website internally, and the company either does not have any documents on such development or does not have any delivery and acceptance act of this work from a third party. So it all leads to the potential loss of the exclusive rights to the objects used in the website, such as software, any other images, and so on and so on and so on. So make sure that there is a respective agreement between you as a company, as a customer, and a developer of a website. Next. The next violation is also a very common thing when companies launch as a startup, and the domain name that hosts the company's website is registered in the name either of a beneficiary or in the name of the IT specialist who was involved in the process of registering the domain name. And accordingly, it happens that an IT specialist leaves for another job, for example, and does not transfer the domain name to his former employer. And then the company needs to either bargain with this IT specialist or sue him if there are any legal grounds. Both options involve time and financial losses for the company, which can be easily avoided. These consequences also are corresponding if a beneficiary, for example, sells a company in which the asset is a website, but the domain name is registered in the name of such beneficiary. So make sure that the right to the domain is transferred to the company, and its administrator is not a beneficiary owner or IT specialist. We saw it in numerous situations. Next violation. Next violation, we found this example insanely interesting. The background is as follows. There was a group of companies, and one of the companies developed a computer program, software, and wanted to transfer the exclusive rights to that software to another company of the group. And according to the current legislation, Russian legislation, this agreement on the alienation of exclusive right to the software must specify the remuneration. And the alienation agreement submitted to us for the analysis stated that the purchaser of the exclusive rights to the software as a remuneration should maintain its performance and refine its functionality. Therefore, the purchaser of the software economically did not pay the seller for the program, but as it were himself. So it was acting for himself and not for the purchaser. So there were no any remuneration which is considered under Russian law. Such agreement may be recognized as null and void, and the purchase of the exclusive right to the intellectual property may lost his right. So it is necessary to analyze the wording of your alienation agreements and to stick with the Russian law. The next violation is also really common, is that we very often do not find any essential conditions without which the contract is considered unconcluded. For example, sometimes two parties conclude a license agreement. In this license agreement, it said that all the trademarks owned by the licensor, the right to use, are granted to the licensee. All trademarks under Russian law is unacceptable. It must be stated which exact trademarks with numbers and so on, so on, so on, would be granted under this license agreement. So these agreements which miss any essential terms may be recognized as null and void, and you should analyze your agreements on the compliance with the material terms of the under Russian law. The next violation. This violation, following situation. For example, there is a group of companies, let's say 6 companies. And at the same time, there is also an investor, a buyer, who wants to buy only the part of the business. For example, 3 certain companies from the group of 6 companies. And the trademarks, which identifies the activities of these 3 companies which investor wants to buy, is registered to the company which are not included in the perimeter of the transaction. So the trademark is registered in the name of other 3 companies which will be not included in the perimeter of a transaction. Thus, the investor may eventually get into the situation where he will be either have to buy this trademark from the seller after the transaction, when he identifies the situation that he has no any rights to the trademark he will have to either buy it from the seller or change the name of the acquired business. and this a lot of money and a lot of time, and it's maybe he'll have to go to court. So we advise you to make sure that the trademark is disposed to the company, it is within the scope of the transaction, or the respective license agreements are in place. Okay. And the next violation. This violation is rather common. It's about that companies use their logos, but they don't not register them as trademarks. So as you can see, the notion of logo is not stipulated by the Russian Civil Code, and the logo is basically an image. And if you use an image, you need to obtain written consent from the right holders of the image, or to enter into agreements with the right holders and to buy these images, or to license these images to use such images. So even if the images are not registered as trademarks, please be advised that you need to receive a consent from the right holders of such images. So it's not the fact that they are not registered that you can use it. Yes. So please keep that in mind. Okay. So basically, these were these 9 violations, which are really interesting, and we commonly identified them as a part of legal due diligence. So if you have any questions, please ask me. I would be delighted to assist you. Thank you so much.
Thank you very much, Grigory. I can also see Anton is online. I don't know whether there are still problems with the internet connection, or Anton is probably ready to add something. Anton?
Hello, colleagues. I'm here. Unfortunately, my internet is still not very good, so I will not switch on the video camera, just to have at least some connection to be able to hear you. So what I would like to add to the presentation which Grigory has delivered is the following. First of all, I'm very glad to see all of the participants of the webinar. I can see that there are a lot of people, which means that the topics which we are discussing are of a great interest for them. So first of all, I would like to thank the organizers, the British Embassy in Moscow, for the opportunity for us to deliver our presentation and share with you our thoughts and observations concerning common mistakes of different companies working with IP. In general, I'm glad to notice that attention of Russian companies, and of course other companies working in Russia, to IP has increased significantly over the past several years. To give you an example, several years ago, I had an experience of working with one of the biggest companies in Russia. It's a Russian corporation, and had various discussions with one of its directors whose duties included working with IP. It is hard to believe, but I had to convince him that IP is important for his company. And he said that his company working in certain mining industry, we will not name it, had a lot of things to do, and IP was not important for the company. But it's not, of course, the case, we all know, especially knowing the experience of foreign companies working in the same very industry, and especially knowing how the same very company is working now. So nowadays, Russian companies are very much focused on the creation of IP. And in certain cases, I would say they are a bit too much focused on IP. So they sometimes do not want to produce oil, gas, supply electricity, but want to create software instead. In certain cases, however, this IP created by Russian companies is very good. For example, once we supported one project concerning artificial intellect in geology. So it's a very good IP, very good software in the world market. Grigory and we participated in one of the first blockchain projects in Russia in civil aviation. This project related to fueling. So these new technologies are very good. They are very modern all around the globe. However, it's important not only create the IP, but also duly register it, formalize it, and protect. That's why we decided to deliver the presentation on this topic, which Grigory mentioned. So to do everything correctly, as Grigory had to say at our first slide, the due IP management system should be in place, because we found out certain mistakes, but there could be other mistakes. And to avoid all the mistakes when working with IP, there should be a due IP management system. So in November, we will be making a seminar concerning the IP management system. So if some of you will be interested in that, you can reach us and we will invite you at our webinar. Thank you very much, colleagues, for your attention.
Thank you very much, Anton, and thank you very much, Grigory, for your presentation and for highlighting such important aspects that are vital to be taken into consideration for an IT company when dealing with intellectual property. Thanks so much. I would also like to address our audience that they are very welcome to write their questions to our speakers in the chat box, and we will gladly answer them in the end of our session, in Q&A session. And our second speaker is Yulia Gurieva from Hogan Lovells, Senior Associate. Yulia, are you ready to start?
Hi, everybody. It's a pleasure to meet you all and speak on a very important topic of IP rights. Yeah, I'm ready to start, but it feels like my presentation is not coming or how it should go. Oh, okay. It's there. So I'm going to speak about databases in Russia. Basically, databases are protected with copyright, and in many countries they are protected with copyright along with software and other digital products, which became a hot topic in the nearest years, while the copyright exists for more than 100 years. And the doctrine was extended to such products. I will jump to next slide and elaborate further. So, database generally is protected as a copyrighted product, as it represents a certain collection of independent materials which are presented in objective form, systemized in such way that this material can be retrieved and processed by an electronic program, right? So database in any way is related with the software which enables use of the database, but still represents separate IP object. Starting 2008, Russian law provides additional protection to databases, which are huge and in which there were huge investments. So, unlike many developed countries, we have neighboring rights to databases. And this is a rare case when you are dealing with databases in Russia. You need to consider not only copyrights to the database and use of the database with respect to use of the copyright to the database, but also the potential existence of neighboring rights to such database. I will try to give you a particular waterline between those two IP regimes provided to databases. So basically, copyright is something that what is always related to the format, to the form in which an IP object is created. So with respect to copyright work, it's a protection of creative selection of materials or creative compilation of materials or together, like the format in which it is well, in which the materials are structured in the database, but not the contents of the database. So it protects the form, the use of the form, but not the particular materials contained in the database. While I will go to another slide. While neighboring rights, in our case, with respect to databases, protect exactly the materials contained in the such database. Not all databases are protected with neighboring rights. Only those which were required substantial financial, material, organizational, or other expenses on the side of the person who organized creation of the database. So by default, the law recognizes neighboring rights to a database if such database includes at least 10,000 independent materials. To give you an example, for example, our database known to all the lawyers, I believe, is a Consultant Plus or a Garant. They definitely contain this amount of materials because there are for sure more than 10,000 legal acts in those databases. So legal acts could be understood as the materials. Obviously, it's not clear how we would protect these kinds of materials contained from the database or contained in the database because they are legal acts. They should not be protected from extracting and so on and so forth because they are official, right? And here we need to know what is exactly the actual neighboring right to the database. And I will go to another slide. Yeah, here I'm comparing the copyright and neighboring right for you to understand the difference. As I said, the copyright is about creative selection and compilation, and neighboring right is about substantial expenses. And there is difference in the IP owners in this case, because the right holder with respect to database, the initial right holder is a author, while with respect to neighboring rights, it would be a person who organized the creation of such database. And what I started to explain is the exclusive rights. The nature of exclusive rights is different as well, because copyright is protected with quite a substantive amount of ways of use, but it's limited to the format of database, right? While exclusive rights to to the database as a neighboring right is quite limited, and the length of protection is also different, but it's not that much feasible because it's quite extensive, and normally let's say all digital products do not live that long as the copyright and neighboring right provide the title for them. So it's not very important topic. So coming back to the exclusive right, scope of an exclusive right to database as their object of neighboring right is that the only owner may extract database information and use them by any method, provided that extract is the extracting means that there is a transfer of entire database or its substantial part to another carrier. So when you are using a small part of information from a database, you are extracting it, transferring to your files, or so on and so forth. This is not a use of neighboring rights. But if you are extracting entire database or substantial part, like part of consultant plus database, you are extracting and moving somewhere and storing there, or sharing with third parties, or even publish, this is all constitutes a use of neighboring rights and could be done only with authorization of the neighboring rights owner or holder. Here's the big question with the regulation in this field. Sorry, maybe you don't see me anymore because of sunshine coming to Moscow. So here is a very important exception from that rule. The rule said that, well, actually, any non-substantial use of the database is not infringement, but if there is a repeated extract or usage of non-substantial part of the database, and if such use or extracting contradicts to normal life of the database, normal use of the database, and plus such use or extracting violates legal interests if the person organized such database creation, then this is a violation of neighboring rights. And here we come into certain uncertainty, because it's not clear what is not substantial part of a database. Repeated use, whether 2 uses is repeated use, maybe yes, because repeated, and what kind of extracting or using non-substantial part could first prevent normal use of the database, contradict to it, and secondly, which use may violate legal interest if a person organized such database creation. There are other exceptions from the exclusive rights, which are use of the database within the agreed framework. Like you agreed for the use of the database, there are agreed purposes of the using the database, and you just need to use the database within the agreed frameworks. Then you are not violating. This is quite clear actually, but here the one thing from the practical perspective is that normally Russian license agreements related to database do not touch on the purposes of using database, because it's not clearly provided in the requirements to licensing agreement. So here I would recommend, if for example you are entering into licensing agreement related to database use, it is highly recommended to specify their purposes for using the database, because this is where we are in the field of neighboring rights use, especially with respect to big databases, which may be potentially protected with a neighboring right. And another very common exception for IP rights is the use for personal, educational, or scientific purposes within the scope justified by such purposes. This is free use in this case as well. And about non-substantial use, one-time non-substantial use for any other purposes, I already said. So why I'm talking about this now? Because there is one court case which gave to this topic a bit hotness these days. There is a court case which already came to its second round, and I believe will be heard by the IP Court of Russia within the coming month. It was there before, so it's, as I said, second round. The case between VKontakte and Double Data. Double Data is a company specializing in big data and data mining. They offer services and search and analysis of publicly available information, including information published on VKontakte. They're very popular social network in Russia. So they analyze the data, and their services are particularly very popular among Russian banks, because it allows them to get more information about creditworthiness. So this case is related to the neighboring right to a database, VKontakte. As I said, currently the case is to be considered by the second appeal in the second round, but to the date we have certain conclusions provided by the courts to consider. For example, it was not very clear from the beginning whether a person who organized database creation may protect the database with neighboring rights if the database is completed by somebody else. Like you created a database and somebody without your particular instruction is uploading data to your database, like it's done with VKontakte. Their users are uploading their personal data and pictures and so on. So basically the database is growing itself without particular instruction of the database, the owner of the neighboring rights to this database. So IP court said, well, actually it works, because I believe the economical there is an economical understanding of that if somebody promotes VKontakte between users, they are attracted and they are uploading the data. That's why the database is growing. So to the date, we may certainly come to conclusion that database could be amended by third parties and grow with their efforts. and social network could be protected as a database. Obviously, it should meet the requirements to the database. Measure questions which are to be considered further by IP court with respect to this date, in my humble opinion, I would say. Obviously, I cannot say what IP court should do or shouldn't. So these are questions which I actually ask myself when I look at this case. Does parsing of information constitute use of neighboring rights to a database? Parsing of information analyzes publicly available information, right? So the appeal courts in this case decided that yes, parsing constitutes use of neighboring rights. I don't think that it was very well and clear grounded there in the decision why they decided that parsing is use of neighboring rights, but they just decided that while there is automatic analysis of the publicly available information, it could be considered as extracting data, and therefore there is a use of neighboring rights. But let's see what IP court would say about this, because court of first instance said that this is not a use. Court of appeal said this is a use. Now we will wait what would IP court say about this. Another question, does extracting of a database user's personal data violate legitimate interest of the person organized creation of VKontakte? Here's the Court of Appeal in the second round said that yes, because there is a user agreement with users, with the data subjects who upload the data to VKontakte database. And according to the user agreement, VKontakte undertook to protect the personal data. And that's why VKontakte has legitimate interest to keep the personal data, whether they published or not, from third-party use, which is not directly authorized. This is a bit, a concept which may be somehow reconsidered by IP court, in my personal understanding. Obviously, let's see what will happen. I would, as I'm not only IP lawyer but personal data specialist as well, I see certain discrepancies here, because as you may potentially know, from 1st of March of this year, our Russian regulation of publishing, dissemination of personal data has changed. And clearly, if, for example, the data is parsed and the person who is getting the data after parsing has grounds for processing such data, like consent, like, for example, user came to a bank, asked for a credit and gave his consent for parsing, then, this criteria falls apart, because there are grounds for the banks to get this information, and they're using the double-dated products. So I eager to see what IP court would do. And I see that my time runs out. I would just, at the closing moment, mention that actually, if there are no grounds for collecting publicly available information constituting personal data, then parsing of such information could constitute infringement now, rights because of the changes I just mentioned a few minutes before. So this is something we need to keep in mind as well. That's it. I believe I try to give you a picture of what's going on and what's changing with the database and databases. I would be happy to answer any questions you may have.
Yulia, thank you very much. We will now keep a close eye on VKontakte in IP Court with their second round. And definitely, well, the wise use of database, considering IP rights and clarifying well, the difference between these copyright and neighboring rights is definitely important for us, not only at the business level, but also at personal levels. Yulia, thank you very much. And our last but not least speaker for today is Katerina Polikova from Deloitte, senior lawyer. Katerina, we are looking forward to your presentation.
Yes, thank you. Could you please share it? Dear colleagues, participants, as Anna mentioned, my name is Katerina Polikova. I'm a senior lawyer at Deloitte CIS. I'm in charge of intellectual property practice there. So I'm delighted to be here and thank you for inviting me. My report is dedicated to legal aspects of know-how, and I've divided it into two main parts. In the first part, I would like to cover the benefits and legal criteria of know-how and try to emphasize the difference between such definitions as confidential information, commercial secret, and know-how itself, according to Russian legislation. And in the second part, I'm going to cover and describe several cases in respect of transfer rights of know-how to know-how, and describe current trends in challenging deductibility of royalties for know-how. So, in my personal opinion, the main advantage of know-how, of using such object of intellectual property as know-how, is that this type of intellectual property allows protect sensitive or valuable information technology in case when it is impossible to use such legal institute as copyright and patent law. Of course, if legal criteria of know-how are met. If we look at the definition of the know-how, we understand that the first, it is an information. This information is related to intellectual property or way of doing business. And this information has commercial value and can provide economical effect due to any third parties doesn't have access to this information, and the owner takes measures to keep this confidentiality, to keep this information in confidential. The main feature of know-how is that the exclusive right to know-how arises from the moment when the owner starts to implement confidentiality measures for such information. And the second advantage of using know-how is that the exclusive right to know-how remains in effect until the information is treated as confidential. And in this way, potentially, the term of exclusive right of know-how can be for a very long time. Now let's look at the correlation between such definition as confidential information, commercial secret, and know-how. We see on the slide the image which show that the broadest definition here is confidential information, and trade secret or commercial secret regime and know-how are included in this big definition, confidential information. Such correlation means that this definitions are not equal and have their own legal specific aspects. I also would like to draw your attention that to the fact that before the 1st of October 2014, it was obligatory for the owners to implement commercial secret regime with respect to know-how. And now this obligation is not mandatory. So let's consider one of the risks that may arise in connection with the conclusion of the license agreement for using know-how. Let's imagine the situation when some company owns some valuable and sensitive information and provides such information to another party. And after a certain period of time, parties decided to conclude the license agreement. In this situation, in this case, it is quite common that tax authorities try to treat or to challenge this agreement as null and void on specific legal arguments. For example, tax authorities say that if the transfer of technology was carried out before the conclusion of the license agreement, the value of such sensitive information has been lost, and such information was disclosed. Thus, at the time of the conclusion of such agreement, the know-how was no longer protected as an IP object. In next slide, I was going to describe another situation which is related to disclosure some part of know-how, some elements of know-how. In this case, parties entered into a license agreement for using know-how, and after a certain period of time, licensee started legal actions against licensor, trying to prove that the agreement is null and void based on the fact that he had been seeing some information of know-how, some elements of know-how on the internet. The court examined the issue and concluded that disclosure some elements of know-how doesn't obligatory mean that the whole know-how is disclosed and its protection ends. And third case is related to the derivative know-how. Derivative know-how, it is a know-how which is created based on another know-how, original know-how. And derivative know-how arises when the licensee, for example, try to improve original technology which he had been provided by under the license agreement. And the key issue here is who owns the exclusive rights to such second know-how, such derivative know-how. And in order to avoid any disputes between parties, we highly recommend to stipulate, to specify in the agreement provisions related to ownership of such derivative know-how. Now it is a final slide. We analyzed several cases which were related with two transfer rights to know-how. And here I'd like to focus the main trends in challenging deductibility of royalties for know-how based on recent Russian court practice. The main risk here is that the payment of royalties for know-how is fulfilled by a subsidiary to the parent company. In such situation, tax authorities can use following arguments to challenging such deductibility. For example, tax authority try to apply rules of reducing the tax base here and try to requalify the royalties into dividends or other income. Also, tax authority tries to apply transfer pricing rules for such situation, and during the examination, tax authority deeply analyze the legal and technical documents which describe the whole know-how and the essence of the technology. And as a result of such expertise, tax authority can assess whether this technology is novel or not, and for such arguments try to challenge the technology at all. And during such examination, tax authority often conduct site inspections and interview employees, also try to prove that this technology novelty, has economic effect, has value or not. So that's all I wanted to speak, to tell about you, and thank you for your attention. And if you have
Katerina,
any
thank you
questions,
very much
please
for the
ask.
detailed
Thank
and
you.
very structured overview of the know-how legal aspects, like a clear picture of it now. As I see in the chat, we have lots of compliments to our speakers, and I can't see the questions. So we can give like a couple of minutes for your questions. If there are no questions from the audience, then probably we can give the floor to Alf for the closing remarks of the session.
Thanks, Hannah. You want to wait a couple of minutes though first?
Lots of thank yous, lots of compliments. Okay, there is a comment, the last question to comment on technology, the object of rights as technology.
I can comment from my side because it is very broad terminal. From my point of view, technology, it is a complex of different type of intellectual property, and of course it consists of different types of software, database, and another information which can be treated as a know-how. So if legal criteria of know-how are met in this situation, such part of technology can be treated as know-how. And as Yulia mentioned, another type of object database can be treated as copyright or neighborhood rights, also in this technology. So technology, it's more about product as an IP. So, and as a product, it consists of different types of IP, for my opinion. Maybe my colleagues also.
I would agree. Well, actually, technology could be anything. Not only know-how or patented invention, it could be a collaboration of all of them together. I believe trademarks are normally not included in the technology, but all digital products which are potentially protected with IP rights could comprise a technology. So it's not a legal word, it's something to sum up different types of IP objects.
And I would like to add that if we think about this definition, technology, in the broad, in general, it is something. It is a way of doing something, actually, because technology, it's like an algorithm to doing something. How to write, how to walk, and maybe it can be related with digital and producing something.
Yeah, and there is a question about how to protect technology in general. Well, first you need to understand what exactly you are protecting there. So you look at the product or process which you consider as technology and try to understand what is inside and whether you need patenting protection, or certain parts are protected by copyrights due to the creation, because copyright doesn't require any registration, and whether there is something which should comprise a trade secret or know-how, so it's better not to disclose to anyone, so the product has its commercial value. So there is no one answer to this question. You always need to look at the particular technology and understand what is it from the legal perspective.
Okay, great. Thank you for your answers. As I see no further, okay, no, there is one more question. There is one more question. You can see in the chat on IP rights and how to protect them in the internet. Is there any real practice? How to protect your personal data, I guess, in the social media, whether it is possible at all when you write complaints.
It's not clear from the question whether it's about protecting your own intellectual property, or your, because it's the question said that there are problems with detection of owners. Oh, okay. So it's about, like, somebody is infringing your copyright or other IP on the internet, and you would like to find them and stop the violation, right? Basically, yes, there is a practice. The common approach would be, first, you need to understand where it is violated. If it's on a web space, like any social media or whatever, you would need to apply to policy of such web space, to look at the policy and follow the instructions how to communicate there. If this is a case, you would need to evidence your title. Like if it's a trademark, you need to define what trademark you are protecting, and the fact that you are a legal representative, or actually the owner of the trademark, and then proceed with the claim. If it's a violation in the free internet, I would say that somebody on its own website violated the trademark. It's more complicated if there are no contact details. Then the normal way would be to send an advocate request to the domain registrar to get details of the domain owner, and for the purposes of filing a lawsuit, and maybe first send a cease and desist letter and then proceed with a court case. Well, there are many of such cases. As you may know, there is a simplified procedure of taking down copyright violations through Moscow State Court. But it's a long story, actually. I don't know how much time do we have. There are more questions. Maybe somebody else would want to comment on this too. Do we have time, Anna?
We have 20 minutes, 19 minutes.
Oh, okay.
Yeah.
Okay. So upon receipt, the response to an advocate request which could be addressed by an advocate, Russian advocate only. And obviously we're talking about the registers which are located in Russia, because Russian advocate request to a foreign company is something which is not clearly would be followed and performed. So upon getting the information on the domain owner, you may contact it directly through the information, and if there is no response, it would be an easy case actually if there is a clear infringement online. So you just take a picture of the I mean the screenshot of the violation, show that you try to communicate and nothing happens, and then evidence to court that there is a violation. Obviously I'm talking about straightforward case when it's clear that somebody is infringing your copyright or trademark, and the trademark is infringed in a way which is covered by the registration, like trademark is registered with respect to such use of a trademark. Yeah, maybe somebody else would want to comment. No?
There is another question, probably you see it, regarding copying recommendations from marketplaces or different websites.
Copying the marketplaces reviews, I believe it's a user review of a product. Whether it would be a use of a database. If you are copying all of them, for sure. If some of them, well, we will come to a question whether it anyhow infringes the legal interests of the database owner. And this is something what would require certain analysis. How you copy the responses of users or reviews of users. If you copy only the information, like not referring to a particular person, I would say that the risk is less than if you are copying the entire or a snapshot, doing snapshot from the database or something like this. The risk is higher. There was no cases related to such use of the database. Well, and I need to say that in such case, if you are copying few of them related to your product particularly, then I don't see particular interest in the marketplace to sue, because the commercial side of this is that marketplaces show that user come to the marketplace and finds anything it would like to, and there are references to the websites who are selling those products. Marketplace some marketplaces definitely sell them, but a marketplace itself do not promote products which you are selling. So it's a bit different question, because marketplace, obviously they analyze the data they receive in different ways, but I don't see the commercial interest of a marketplace to prohibit a shop selling such products from referring to the users' reviews on such marketplaces? Because, yeah, maybe.
I also would like to add that I think first we should analyze the user agreement of marketplace and understand who is the owner of such feedback. And can we treat such feedback as intellectual property, for example, work of literature? Maybe it is an image as a feedback, and who is the owner? And maybe in this case, we should try to have a right to obtain right for using such feedback. But reasonably, I don't believe that some sentences about, oh, it's a good product, I like I enjoy it, I like it, is constitutes some intellectual property. And if the producer of such product want to fill his site such information, because it's more likely information than intellectual property, and according to Russian law, information itself is not a protected object. We can use information, we speak, we talk, and it's just words. So but as Julia mentioned, if somebody takes whole feedbacks from this site, it can treat it as some infringement of something.
For sure, unless it is a poetry review of a product, it's likely be protected with the copyright. But I believe the question is about when, for example, a big big online shop would copy reviews of its products on the marketplaces and put it on its website. So there is a risk of using or repeated use of non-substantial part of the database. And here we come to the neighboring right to database, whether it's protected with neighboring rights and whether it is actually constitute a use of neighboring rights to, the questions actually I mentioned on the VKontakte and double data case. So there is a certain risks if you are doing this constantly in a big amount, and there is a commercial interest of a marketplace to prohibit this, okay? Because this is actually the main idea why marketplace would spend money for having certain legal services to run the action against such an internet shop.
And I think another side is key issue how to copy. If it is a screenshot and this copy contain design of website of marketplace, it can be treated as infringement of the design sites. So you can understand how you copy such extract feedbacks.
So many details you need to go into when considering one aspect, one story, or one issue. I don't see any further questions, but I'm definitely very glad and delighted that we had, despite all the COVID restrictions we are having today, that our speakers are here, and so many people among audience were also with us today. And Alf, I am please feel free to close our session today.
Great. Okay. Well, thank you very much, Anna, for organizing today's fantastic event. And of course, to our speakers, Grigory Moskalev, Yulia Gurieva, and Katerina Polyakova. That was a really thorough and interesting overview of three, very interesting areas of IT companies and how they deal with IP, databases, and know-how. What strikes me is, firstly, how complex some of these areas are, and I'm glad we got such capable experts explaining it to us. but also the words of Anton Chernik, who I didn't mention because his was a cameo role, but very valuable nonetheless. And that was that IP affects everyone. And the reason it resonates with me is we were working with a company who spent a huge amount of money rebranding, only to find that all the rights to that name were actually owned by a very small company up in the north of Russia. They had no idea of this, and they spent literally millions on it, only to get them into all sorts of legal problems trying to unpick the mess they found themselves in. Anyways, thank you very much to our speakers, and of course to the audience for joining us today. I know it's the first day of the lockdown, so I hope you'll keep safe for the rest of it, and hopefully we'll come out the end of it in good shape. This, as Anna has mentioned, and I mentioned at the beginning, is a series of legal discussions. There will be more, so keep your eyes on the websites for more details, and we look forward to seeing you again in the near future. Thank you very much, and have a good rest of the day. Bye-bye.
Thank you.
Thank you.
Thank you. Bye-bye.
Thank you, bye.